Good morning. We are here with Mike Kuna from Kuna Law Firm PLLC for another Ask an Attorney question. Good morning, Mike.
Good morning, Jillian.
Thanks for joining us today. So today's question is, my boyfriend and I own a business and we received an offer from a contractor to give away some of our shares if he builds us a place and joins our business. The problem is that he wants to own most of the business. We are so confused right now and have no idea what to do. Please help us, Attorney Mike. So it sounds like this is a small business that they're working with. So what if they're in the same predicament but in a larger corporation?
Okay, that's actually a great question. This is part of corporate law that I will try to explain as simply as I can, but again, highly nuanced form of law and definitely needing the expertise of a corporate attorney. Let's treat this offer, and the way it sounds to me is that this is not a friendly takeover offer. This is a hostile takeover attempt. If we would have been a big corporation, the hostile takeover would have been taken in the following path. The company trying to purchase the company who is the target would have made an offer to the shareholders called a tender offer to give them more money than the shares are actually worth. Meaning, let's say a share is worth $20, they would have offered for each share $25. Or they would have conducted a proxy war, meaning convincing the shareholders to change the board of directors who rejected the offer. The board of directors would have had two options together with the shareholders: either to make the share price itself higher, or to make sure that if the directors are fired because they don't want the offer, they will have a very nice benefit package that will basically make that deal null and void, because nobody will want to purchase the company afterwards. How can we attribute this to a smaller company? Very easily. If somebody offers you a huge amount of money, but then he purchases most of the stocks, you become a minority shareholder, basically without any ability to make sincere decisions. However, now we need to come back to the initial stages of forming the company. When you formed that company, did you have an attorney? Did that attorney draft articles of organization, bylaws, an operating agreement, a constitution? All these elements are very important, and it's much easier to conduct business, whether in the forms of purchase, sale, or daily business, when you have a set of documents set in place. Even if you didn't have those documents, it's recommended to have all your documents in order and organized prior to making decisions on such important subjects. Further, this deal might be $1 million deal, might be a few $100,000 deal, but this is a very big deal, which includes real estate law and corporate law. I highly recommend you to call me and let me consult you and give me the full details about this deal, because clearly there will be contracts made, and those contractual obligations, even though it's a piece of paper upon which you sign with a pen, are mandatory and obligatory and can be discussed in court and can be basically filed for lawsuits against if you violate them. Also, there can be penalties outside of the courtroom. There can be arbitration clauses. This is just way too complicated for me to explain it in the 4-minute timeline that we have. Just contact me directly and we'll speak about it in person.
Yeah, absolutely. And I love that you said that it was difficult, because before you're just like, I'm going to take this corporate problem and transfer it to a smaller business very easily. And then you just went into it, and it is a very difficult predicament that they're in. And the way that you explained it was great. So for us that are non-professionals, we need to reach out to you guys.
Well, thank you.
Yeah, absolutely. So if you have a question that you would like to ask, you can go to our website at valleynewslive.com and click on the Ask an Attorney tab. We'll have more North Dakota Today coming up right after the break.